Good day, my name is Mark Malore. I'm an attorney here in Riverside, California. I've got a number of clients in Calimesa facing financial issues, thinking about filing bankruptcy. So I thought it helpful to put together a quick video detailing some of the distinctions between a Chapter 7 and Chapter 13 bankruptcy. The first distinction between the two is that in terms of time. A Chapter 7 can be resolved typically from filing date 90 to 120 days after filing, whereas a Chapter 13 takes 3 to 5 years. You might ask what the distinction is between them. And that's the second distinction to make between Chapter 7 and Chapter 13, is that a Chapter 7 is a discharge of all your debt, whereas a Chapter 13 is a repayment to your creditors in a certain amount, whether that's 90 cents on the dollar or 10 cents on the dollar. Doesn't matter what it is, you're still in a repayment period to your creditors for 3 to 5 year time place. So, and that's decided on by the trustee. So if you look to that, one takes 90 to 120 days, one takes 3 to 5 years, and the reason is because you repay the debt with a Chapter 13, you don't under Chapter 7. Now, the third distinction between the two is that you must qualify to file a Chapter 7. You don't automatically get to file a Chapter 7. If you don't qualify for filing a Chapter 7 under what we call a means test, then you're relegated to filing the Chapter 13 under the repayment program. Now, how do you qualify under the means test? Well, there's California statutory median income, and as long as your income after deductions and dependents falls below that income, then you could file the Chapter 7. If your income is still above that California median level, then you're relegated to filing a Chapter 13. You must repay your creditors a certain amount of money, depending on what the trustee figures out and for the period of time. And then finally, one of the distinctions I want to make for you, because I've had some clients come into my office that have done them on their own or seen paralegals to do them for them. They see billboards, $500 or something like that. And they come to me saying, how do we strip the second from our home? If you've heard of lien stripping, you have to understand first that it's only available to you in a Chapter 13 bankruptcy filing, not in a Chapter 7. And I can't tell you how many people come to my office requesting we help them with the lien stripping after they've got Chapter 7 that's been discharged by the bankruptcy court. It's not possible. You can only discharge the lien or lien strip in a Chapter 13 after the repayment period. And you can only do so if the value of the house falls below the value of the first encumbering the home, because then there's no equity that would pay the second on the home, and the trustee will allow, or the judge will allow, the lien stripping process to occur. You file a lien stripping motion, and then after the repayment period, the court will strip the second from the home, which gives you an immediate injection of the amount of the second back into your equity. So those are some of the quick distinctions to make. If you have some particular circumstances, facts, or things you're concerned about, assets that you want to keep a hold of, feel free to call my office and make an appointment. We'd be happy to sit down with you and discuss those issues with you.